So a warm welcome to one and all participants and fellow IPs. Good evening, everyone. On behalf of IPNet East Region, I would like to extend a warm welcome to all of you to today's webinar titled Managing Attachments, Interplay of PMLA, PF and IBC. We are truly honored to have with us two distinguished lead speakers, Mr. Narayana Kamma and Mr. Vinay Kumar Singhania. Your presence today adds immense value to this session. As you are aware, IPNet East is hosting its third webinar in a series of webinars organized periodically under the umbrella of IPNet, the National Network for Insolvency Professionals. Now, without further ado, it is my pleasure to invite Mr. Rajiv Kumar Agarwal, member of the National Executive Committee and Regional Head of IPNet East, to deliver the formal welcome address. So,
Good evening, everyone. It's my pleasure to welcome you all to today's 12th webinar on managing attachments, interplay of PMLA, PF and IBC. We are privileged to have Mr. Narayan Kama and Mr. Vinay Kumar Singhania as our esteemed keynote speakers. A special thanks to Sri Ashish Pakhija, President of IPNet, for his visionary leadership in shaping this platform. The membership link is available in the chat, and we look forward to having you with us. IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, collaboration, and professional growth. We are committed to supporting IPs through expert-led learning initiatives like webinars and study groups, practical guidance on IBC-related challenges, and a dedicated member portal offering comprehensive resources. For those who are already part of IPNet, thank you for your support. And for others, I encourage you to join this dynamic network. Membership details are available in the chat. Thank you for being here. Let's make this session insightful and rewarding. Over to Mr. Vivek.
Ravindra, please run the video. Ms. Namrata.
Namrata, please run the video, please.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field. From specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen, IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Thank you, Namrata. Just run the back video also.
Thank you. I now request Mr. Namrata to introduce our speaker, our first speaker, Mr. Narayan Kama, who is a retired additional central PF commissioner.
Thank you so much, sir. Good evening to one and all. Thank you for giving me this opportunity to introduce Mr. Narayana Kama. Kama, sir, passed the limited insolvency professional exam conducted by IBBA in December 2020 and is a registered IP with IBBA. He is also a member of panels of SEBI. He is qualified advocate enrolled with Karnataka Bar Council. After serving 25 years in the Employees Provident Fund organization, Mr. Kama retired as Additional Central Provident Fund Commissioner in August 2020. During his tenure, he was deputed as a recovery officer at the Debts Recovery Tribunal, Bangalore, where he played a key role in reducing NPAs for banks and financial institutions. From 1983 to 1994, he has served as an inspector of police with the Central Bureau of Investigation, investigating cases under the Prevention of Corruption Act, including several high-profile bank fraud cases. With this, I request Mr. Kama, sir, to kindly give his keynote address.
Thank you, Namrata ji. I thank Ashish Makija and IPNet for giving me this opportunity to interact with the IPNet members and share whatever experience I have in the field of Provident Fund. I hope my interaction here would be helpful to my fellow professionals because Provident Fund is one issue which most of us during the either in CRPC or liquidation, we come across dealing with the department. So I was asked to take up having this experience in this organization. I thought maybe I should share with all of you. Thank you so much. I once again thank the IPNet, Ashish Makija and other members of IPNet for giving me this opportunity. Let me start. I have already told Mr. Ashish Makija that I'm not very comfortable with all sorts of presentation. I have a note which I will share and go along discussing. My presentation is in two parts. One, the first part deals with the provisions of EPFO, which have some bearing on IBC provisions. And the second part is dealing with these provisions vis-a-vis the judgments and what exactly is the current status, how do we deal with the Provident Fund claims in course of our CIRP and liquidation. Let me first share my the note. Madam, can you permit me to share? I think, okay. Yeah. Presentation, just a minute. I don't know where my screen is.
డ్రాఫ్ట్ ఇది చేస్తాను అంతవరకు చూద్దరు కానీ తర్వాత ఫైనల్.
So this is what I have prepared. I will share the notes subsequently. To start with, what are the provisions of PF? One of the most important provision of PF is relating to the priority of payments of contributions over other debts. This Provident Fund dues have been held to the PF Act Section 11. Just give me a minute. I don't know. I'm not able to get my correct presentation on screen. Let me check. Oh, wait. Just a minute. Just a minute. Yeah. This screen is visible? Hello?
Yes, sir. It is visible.
Yes, sir.
Yeah. Yeah. These are the provisions of Provident Fund Act which are relevant to us. Section 11 of EPF Act is very important. It deals with the priority of contributions over other debts, priority of payment of contribution over other debt. This is a non-obstanta clause which is specifically introduced in EPF Act, and it has been there since 1952. And over the period of time, there were amendments and certain additional provisions have been added. But as it stands today, this is the provision where it very clearly and categorically states that the provident fund contributions have to be paid in priority over all other dues, all other debts. So this is a very important uh, uh, provision which affects most of us in while we are dealing with the IBC provisions. Then this is the most important provision as far as I am concerned. Second, EPF scheme has got certain provisions where the duties of employers have been specified, because as IP or as liquidator, we step into the shoes of the corporate debtor who under the EPF Act is considered to be the establishment. So you represent the establishment. So all those responsibilities which were there with the employers under the EPF Act are now bestowed on the insolvency professionals, RPs and liquidators. These are certain things which are very important, because in case you are running a going concern establishment, you will be responsible not only for filing of all the returns and also making payments on time. Because any failure to make payments, if there is a default in payment or default in submission of the returns, these attract penalties, and penalties are pretty severe. Some of the penalties are criminal in nature, especially if you are running a show and if you have if you deduct you while disbursing the salaries, if you have deducted the employee share of provident fund, and if you fail to deposit the same, you are liable for action under 406, 409 IPC. So my simple advice is anybody who's running a establishment as a going concern, if a salary is disbursed, the first thing one needs to do is pay out the employee share at least. As far as the employer share is concerned, there is some immunity. But for employee share, it's a criminal offense and there's no go for us. There are other responsibilities. Once a company comes into CIRP or goes into liquidation, either the RP or the liquidator needs to intimate the provident fund authorities about the change in ownership. Means now he is the authorized signatory and he should intimate online and get his name registered with the provident fund, because he needs to deal. He will have the authority to either approve the claims and all other reasons. His digital signature needs to be shared with the provident fund authority. Then this is the provision relating to the payments to be made, how the contributions are to be made, what is the time given. It's normally within 15th of the month after of the next month of the wage month. Before 15th, the contributions need to be paid along with a challan called ECR. This needs to be simultaneously submitted online. Any delay beyond 15th.
Narayan Garu, your slides are not moving. We are in the second slide.
I'm moving.
Overview of EPF Act only is
No,
showing.
I'm sharing some other one that's not coming. I thought I shared the other one. Okay, 1 minute.
I think this is the second slide, I suppose.
No, it's not that. Okay, 1 minute. There is some confusion in that. This
I
is
think,
the
sir,
note
what you can do is please unshare this and then try to reshare whatever.
Okay, sir. This is stop share, right? Okay, fine.
And then you can start sharing whatever document.
Okay, I will share this now. 1 minute. Let me go back. Please share. Yeah, this one. Now a different slide has come, sir.
No, we are not able to see it, sir. You have to share it.
Okay, 1 minute. Just a minute. I am finding it difficult.
Doesn't matter, sir. You can continue just like that. I think people.
Okay, sir. What I will do is I'm going through the presentation. I will share this presentation separately.
Or in the meantime, sir, if you are in a position, can you share it on a WhatsApp to any one of us?
I will do it, sir. I will do it right now, sir.
We will share it from here.
I will do it, sir. Just a minute. Give me while I'm talking. I will try to do it.
Please do that.
Sir, this is okay. These are the contributions to be paid, and these contributions have to be paid within Okay, sir, this is, I'll, 1 minute, sir, I'll request Hari sir to see if he can share this one. Hari sir is having my, I will just, anyway, I will complete this and share it, sir, no problem.
Sure.
Okay, this mode of contributions have to be paid within 15 days. I will share the slide subsequently. Then there are provisions. After that, the important provisions which are relevant to us are the provisions relating to recovery of damages. Section 14. Provisions relating to recovery of damages is not so important, but the provision which relates to waiver of damages is very important. There are provisions under the EPF scheme 32B where the RP liquidator or the SRA can seek waiver of damages. There are provisions under the erstwhile SICA Act, and these provisions there are judgments which have permitted the RP to approach the NCLT and seek recommendation for waiver of damages. This is one of the important provision which will help us in reducing our liability towards the damages part. There are two very important proposed legislations which will take care of all our problems relating to IBC. Section 19 and Section 128 of Social Security Code, which has been notified, but these provisions have yet to be notified. I'll just read out this Section 28 second provisions. That is very important for us. Provided further that central board or the corporation, as the case may be, waive the damages levied under this section in relation to an establishment for which a resolution plan or a repayment plan recommending such a waiver has been approved by the adjudicating authority established under the IBC code, subject to terms and conditions as may be specified by the notification in the central government. This is very important because whatever conflict we are having and whatever differences we are having between IBC and Provident Fund, if these two, we don't need any other amendment and we don't need any other judgment. Once these are done, especially the damages part, which is a major chunk of money which we need to pay to the Provident Fund, will be taken care of because there is a specific provision which relates to that. Similarly, Section 19 of the proposed act says, notwithstanding anything contained in any other law for time being in force, any amount due under this chapter shall be the charge of assets of the establishments to which it relates and shall be paid in priority in accordance with, please note, in accordance with provisions of IBC. So therefore, if this Section 19 and 128 second proviso gets notified, all whatever has happened over the period, the evolution of the law relating to payment of Provident Fund will get cleared if these two sections get notified under the EPF Act. Now, after having dealt with whatever the provisions which are there, I have now come to the PF laws which deal with which are very relevant to our topic today. The first law which I am discussing is in the case of Supreme Court case of Bhupender Singh versus Unitech Limited. It was decided in 2020. The Supreme Court has observed that the Supreme Court has agreed that the order of moratorium should not foreclose the statutory entitlement of EPFO to enforce the claims of the payment of PF and other related statutory dues per law against erstwhile management. This is very clear that PF authority can continue to proceed against the erstwhile management to get their, or they can go ahead and enforce their recovery mechanisms against the erstwhile management because they have powers to deal with them personally as well. The next important and very important case is the first one which has got everybody in the IBC fraternity talking about EPF was after this State Bank of India versus Moser Bear, Karmachari Union and others. The adjudicating, let me just say that here what has happened is adjudicating authority having come to a finding that aforesaid funds, provident fund, pension fund and gratuity fund do not come within the meaning of liquidation estate for the purpose of distribution of assets under Section 53. This was the first case where the interplay started where all IPs were worried. Earlier, they were not willing to agree that the liquidation, the provident fund dues had to be paid in priority. This was one of the cases where it was very categorically held that the payment of provident fund, gratuity fund in accordance with 36(4)(a) of the IBC was held, given an importance, and they said that the amount of provident fund, and these are beyond the liquidation estate, they have to be paid in priority over all other dues. Similarly, this was upheld by Supreme Court as well. Then next, again, this particular, there was another judgment of NCLAT called Guru Narasimhamurthy Venkatraman, where it was observed that main contention of the appellant is that Section 53 of IBC is not applicable in EPF case. Since EPF Act is a special act and prevails over all other acts and submits that dues are payable to the employees cannot be treated as part of asset of the debt. So it was clearly held that there is no dispute regarding that. We are in agreement with the said provision of law. Even Section 36(4)(a)(3) of IB Code states that following shall not be included in the liquidation assets and shall not be used for recovery in liquidation under subsection 4 of Section 36 of IBC. The following shall not be included. This is what the section says. All sums due to any workman. This is what the provisions say. All of us are aware of that provision. The next, again, the Tourism Finance Corporation versus Rainbow Papers. This is another judgment which really started the effect of putting provident fund dues over other dues, and claiming that success here, not only that the successful resolution applicant was directed to pay over and above what he had provided for in the plan. This is what NCLAT held. After hearing both, the NCLAT rightly declared that no provision here, the conflict, especially the conflict between EPF non-obstanta clause and the non-obstanta clause, which is under 238 of IBC, was considered. After hearing both the sides, NCLAT rightly declared that no provision of EPF and MP Act is in conflict with any provisions of the IB Code. On the other hand, in terms of 36(4)(3), provident fund and gratuity funds are not assets of the corporate debtor. There being specific provisions, the application of Section 238 of IB Act does not arise. This is the very categorical judgment where it was said, and this has been upheld by Supreme Court as well, where it is said that the provisions of Section 238 are not applicable vis-a-vis the Section 11 of EPF Act. And now, when I started the discussion, I said the most important section under EPF Act was Section 11 of EPF Act. Then what is that priorities which was there? It was introduced. I will read out what subsection 1, Section 11 EPF provides for priority of payment of contribution in relation to company, which a winding up order has been made under subsection 2, which was introduced by an amendment in 1973. Subsequently, further amended in 1988, recognizes the priority of provident in the following manner. Without prejudice to the provisions of subsection 1, if any amount is due from an employer, whether in respect of employee's contribution deducted or employer's contribution amount due, so shall deem to be first charge of the assets and shall, notwithstanding anything contained in any other law for time being forced, shall be paid in priority to all. This first priority charge under 11(2) and security was recognized by Supreme Court in the case of Maharashtra State Cooperative Bank versus Assistant Provident Fund Commissioner. The interplay between priority of EPF dues vis-a-vis the other creditors during the winding up found extensive attention of two-judge bench of Supreme Court in the case of SK Pharma Limited. In SK Pharma case, the issue before the Supreme Court was whether priority given to the dues payable by an employer under Section 11 of EPF Act was subject to Section 529A of the Companies Act in terms of which workman dues to be paid. After noting the objective behind the introduction of 529A in CA, was to ensure the legitimate dues of workers should rank pari passu with other creditors, Supreme Court undertook a review of the then available jurisprudence dealing with the overriding impact of 529A, which contained a non-obstanta clause. But observe that here, please note, but observe that the propositions laid down in those judgments were of little assistance in deciding question involving so-called conflict in non-obstanta clauses in Section 11.2 of EPF Act and Section 529. In the eventual analysis, Supreme Court upheld the supremacy of Section 11.2 of EPF Act and went on to observe that amendments which were introduced to Section 529, 529 and 530, even though subsequent in point of time, did not have the effect of diluting the mandate of Section 11.2 of the EPF Act. The relevant provisions of the observations of the Supreme Court are detailed. If I think I need not go into those details because look at the time. I will read some of the words here in one of the paragraph. The words all other debts in Section 11.2 necessarily include the debts due to secured creditors like banks and financial institutions. This is in this judgment, it was categorically said that the dues of Provident Fund are beyond even the rights of the secured financial creditors like banks and financial institutions. And it also held that mere ranking of dues of workers at par with debts due to the secured creditor cannot lead to an inference that Parliament intended to create a first charge in favor of secured creditors and give priority to the debts due to secured creditor over the amount due from employers under EPF Act. This is again, it's very clearly said that the judgment said that this provision existed in 11.2 was inserted by EPF Act in 1973, and any amount due from an employer in respect of the employee's contribution was declared as a first charge on the assets of the establishment, and it became payable in priority to all other debts. This is what the Supreme Court while discussing the priority has observed. Then there is one judgment which I have got, where a distinction was made between the priority in respect of priority of payment for debts. Here, in this case, EPF dues had been, this is a case of Punjab and Haryana High Court, Punjab Wireless System versus Canara Bank, where SK Pharma was distinguished in the following manner. Next question is qua the priority of dues payable to the EPFO, although the counsel of EPFO have relied upon the judgment of Supreme Court rendered in EPF Supra. However, the court finds that the said judgment is distinguishable on the facts of the case. Here, why I am quoting this judgment is this is one place where certain leeway is available if this judgment is not being challenged as of now. In that case, EPFO dues had already stood determined and crystallized by EPFO authorities by passing specific orders. Please note these. The dues stood determined and crystallized by EPFO authorities by passing specific orders. Even the properties of employer were attached. Thereafter, liquidation order was passed. Hence, the amount determined by EPFO authorities was taken as a consolidated amount which was given priority over. However, where my take here is where there are no dues determined and specific orders are passed, then the above judgment can be distinguished with reference to those particular dues, which means that whenever a claim is submitted by the EPF authorities for any of the dues, there needs to be a crystallized, the dues had to be crystallized and specific orders as provided under EPF Act should have been passed. What I find in most cases is that the dues in respect of workers normally is supported by a crystallized order passed under Section 7A of the Order Act, whereas the dues under Section 7Q and 14B are normally given as what you call an estimated amount due from the EPF Act, EPFO. Therefore, one needs to consider this particular judgment while discussing while deciding about those things. Then finally, there was there were a lot of differences amongst various tribunals across NCLT and including NCLAT, where what constituted the provident fund dues, whether only the contributions assessed under Section 7A, or it also included interest under 7Q and also the penal damages levied by the Provident Fund authorities under Section 14. Lot of judgments were there which said that the damages need not be paid, the claims were rejected, there were orders passed by the NCLTs as well as NCLAT. But however, there is a latest judgment which very clearly has settled this dispute once and final. In the case of Anuj Bajpai, the question, albeit opposite to what has been held by various benches of NCLT across the nation until now, NCLAT in its very recent decision in Anuj Bajpai ruled that all dues under EPF Act, including those pertaining to interest and damages, do not form part of the liquidation estate and are to be paid in priority. This judgment was basically based on has been supported in the judgment by the Supreme Court judgment in Maharashtra State Cooperative versus EPF, wherein the judgment clearly observed that both damages and interest are part and parcel of dues under EPF Act, and they all put together have the priority while distribution. They stand outside the scope of distribution under Section 53. This is a very important judgment which has laid to rest a lot of what you call differences and different forms of opinion. Different authorities took different cases. So as on date, the judgment of NCLAT in Anuj Bajpai is the law as it stands today. Thus, all dues levied under EPF Act, including those pertaining to interest damages, stand excluded from the liquidation estate of the corporate debtor and are to be paid in priority over all other debts. In this case, this is passed in July. This judgment also I will share. And similarly, there are certain cases where we find that embassy property development judgment also applies, where certain provisions of some of our IPs try to challenge the authenticity or the correctness of the orders passed by the EPFO under Section 7 or Section 14B. That cannot be done before the NCLT. If any appeal has to be made, the appeal has to only go to the EPF appellate tribunal. We cannot go to NCLT seeking any remedy over any incorrect orders passed by the authorities. The principal bench of NCLAT in Sikandar Singh Jamwal versus Vijay Tanwal, relying upon Section 17B. What is 17B? Section 17B deal with continuity. That is, if there is a change in management, both the previous as well as the subsequent employers who are in charge of the company are jointly and severally liable for paying of any past dues. So rejected the submission made by the resolution applicant stating that interfering with the commercial wisdom is very much clear while Section 32E, that resolution plan does not contravene any of the provisions of the law in force. Resolution professional adjudicant authority is to look into the compliance of provisions of law. In this context, we have to refer to 17B of the Act. From the above stated provisions of the PF Act, resolution applicant is also liable to pay the contribution and other sums dues from the employer under any provisions of this Act, as the case may be in respect of period up to the date of such transfer. All this requires that explicit provisions of said PF Act needs to be complied with. This aspect is justiciable as duty has been cast on resolution professional on this tribunal. This is not a commercial wisdom, as compliance of law is must. So which means that if we are not complying or we are not paying with the provident fund dues as are on the date of CIRP, then we are not in compliance with the statutory provisions of law. In this case, the resolution applicant was directed to pay the difference amount more than what he had actually provided in the plan. And one of the last but not the least, the most important one which has come up, and it's also very important, which has laid most of our questions to rest. The Jet Airways case. Jet Airways case very categorically has held that the resolution applicant is bound to pay all the provident fund dues, whether provided for or not in the plan. It was directed to pay over and above what was provided, and therefore the Jet Airways is as important as any other case. So I think the conclusion is employees and workmen are entitled to receive, this is Supreme Court judgment. Employees and workmen are entitled to receive full amount of provident fund and gratuity that is due up to until the date when which the insolvency commenced. Successful resolution applicant is responsible for making these payments in addition to the 24 months. It is important to note that even if resolution plan proposes to pay a partial amount of provident fund and gratuity to the workman, successful resolution applicant is still obligated to pay the remaining unpaid balance of the provident fund and gratuity. This especially is totally and diabolically opposite to the provisions which say that the resolution applicant starts with a clean slate. All dues prior to the approval of plan gets extinguished. Here, it's very categorically saying that if the provident fund dues have not been paid for, the dues of provident fund do not get extinguished, and the liability will continue to rest and vest with the resolution applicant. So this is what this is what is my presentation, sir. And if at the end of this thing I can share I will share that note, sir, that technically I'm not that savvy in sharing. I got, before the other gentleman comes, I will send it by mail to somebody or on WhatsApp, sir. Thank you very much, sir.
Thank you, Kamma, sir. So we will share the presentation as we receive from
I will
him
share it, sir. I will share
with
it,
all
sir.
the participants. Don't worry.
Okay,
And
sir.
I now request Ashish Makhija, sir, to express gratitude on behalf of IPNet and offer a memento to our first speaker. Over to Ashish Makhija, sir.
Okay, thank you. I think Mr. Narayan Kamma, based on his experience, I think he was speaking in a very passionate manner, deliberating the provisions of Provident Fund, dealing with a lot of aspects, and of course, then correlating with the judgments under IBC. So friends, I think this gives us a complete insight on the interplay of Provident Fund. The basic takeaway, which I can take, is that look, as far as PF dues are concerned, they should be considered as the topmost priority, whether in CIRP or whether in liquidation. Of course, I understand a lot of questions would be there. Friends will be taking up questions after the second speaker has also concluded. And then whatever questions you are there, either you can put it in the chat box in the meantime, and then the moderator will coordinate. But I must, express my deep sense of gratitude and thanks to Mr. Narayan Kamma for having accepted our invitation and deliberating and giving us a wonderful, presentation on this aspect. Thank you, sir. We'd like you to stay with us so that after this.
I will stay, sir. I will stay. I will answer the questions. No, that's more. I would be more comfortable doing that rather than speaking.
No, I think you are absolutely wonderful. So over to Mr. Chirania. And Mr. Narayan Kamma, I will request you to, we are sharing the memento. So please accept
Thank
it.
you so much, sir. Thank you so much.
Please accept this, sir. Thank you so much.
Thank you, sir. Thank you so much.
The hard copy of this will be sent to you.
Thank you so much.
Okay.
Thank you, sir. So I now request Ms. Namrata to introduce our next speaker of the webinar, Mr. Binay Kumar Singhania.
Thank you, sir, and thank you for the opportunity to introduce Mr. Binay Kumar Singhania, sir. Mr. Binay Kumar Singhania is a qualified CA with over 27 years of experience and the founder partner of BKS & Company Chartered Accountants. Since 2017, he has been an IP, specializing in IBC, resolving numerous cases as an RP and a liquidator. He is a forensic auditor qualified FAFD from ICAI and a certified fraud examiner from ACFE USA. He also holds certifications in international taxation and anti-money laundering from ICAI. Sir is a regular columnist for newspaper Sanmark and contributes to ICAI publications. He has served as a committee member of the CIBC of ICAI and is currently a co-opted member of the Insolvency and Valuation Standards Board for 2024-25. He is also the Vice President of Use Exchange and has served as Secretary of the Resolve Insolvency Professional Association in 22-23. With this, I request Singania sir to kindly share his address with the participants.
Thank you, Namrata ji, for nice. I'm thankful to IPNet. It has given me a opportunity to deliberate on PMLA versus IBC. It's a very nice subject, and it's very heart-touching to me also. I'm thankful to Ashish Makhija ji for providing such a beautiful platform for all the IPs. In fact, this IPNet will be providing more and more discussions, and it will be giving more insight into the IB code. And all over India, we are having so many chapters, and every chapter is very much enthusiastic in this way. And for last 3-4 months, I am looking after. For last 3-4 months, is giving a seminar on every week almost. From the east side, we have the seminar every month. Likewise, for every region, we have the seminar. And we have good topics, and we are actually getting much benefit on this platform for the insolvency. So now I'm coming to this PMLA versus insolvency code. So I'm not going into the definition part. I hope everyone is aware of. I'm going into the what is the outcome, what is the thing which we have to see in the PMLA. PMLA was started in 2002, and thereafter in 2012 and 15, there were major amendments. Earlier it was toothless. Now it has become, it has more teeth now. So Prevention of Money Laundering Act, as we know, is the laundering of money by some means or other, so that it separates itself from the actual crime that has occurred. So Prevention of Money Laundering Act is a money gained from illegal activities. Those illegal activities have been defined in Schedule 1 of the PMLA Act. In the Schedule 1, there are so many things like illegal trafficking, narcotics, and others. And even the normal murder and ransom money and all other things are included there. So if someone is getting money for all those wrong things, and thereafter it has been converted into a legitimate money, so this is so that it comes out as a legitimate money. So in that way, PMLA is concerned. The adjudicating authority of the PMLA is ED. Usually it is ED. It may go to CBI also, but finally the case is heard by the ED only. So under Section 3, it has been given what is the offense of money laundering, and if the money laundering offense is there, then under Section 5, the power has been given to ED to attest the property which has been gained from the money laundering. It may be directly for the amount which has been taken, or through indirect way also. If the proceeds of crime is there and it has been invested somewhere, it has been given to someone, then those money can also be attached. So attachment is also in two parts. One is a provisional attachment. Thereafter it is a final attachment. Provisional attachment is there schedule of offense is there, thereafter thereafter the ED look after where the money is there. Once it confirms that this money is lying here, which is from the schedule of offense, then they issue the provisional attachment order and they attach the property. Attachment does not mean to take charge, to confiscate the amount property. It is only the provisional attachment so that the person can continue the work, can use the work, can enjoy the property, but it cannot be sold out. So there is a major difference on confiscation of the property as well and the attachment of the property, which we usually forget. In most of the cases I have seen that whenever the attachment is there, all the assets of the CD which is there, those are under lock and key by the ED. But as per PMLA law, this is only attachment. You cannot confiscate the thing. But things are there like they usually attach the property, they have their lock and key, and they normally don't allow the enjoyment of the property also. Thereafter, once the provisional attachment is there, within 6 months, there has to be a final attachment, or they have to release the assets. And once the final attachment is there, thereafter the charge sheet will be filed and cases will be going on under the PMLA authority. They have the special court for that one under the PMLA authority, and thereafter the executing authority is High Court of the jurisdiction where the case is going on. So in that way, the process is going on. Now under IBC, it started only in 2016. Once the IBC started, it was a complete law in itself, and it was clearly mentioned in the IBC that whatever things are there, that all will be covered in the insolvency code. And section 14 was there, which was especially mentioned that once the CIRP process is started, then moratorium will start. Then section 238 is also there, which provides overriding impact of the IBC over the other law. We have the similar provision in the PMLA also under section 71, wherein it is also mentioned that once the PMLA starts, it will be having overriding impact on the other act. As per the common parlance, what we have seen when we argue before the court or NCLT, we have been looking after that the act which has been promulgated or notified afterwards, that will prevail. If the two similar things are there, then in the case of PMLA versus IBC started in 2016, whereas PMLA started in 2002. So the IBC should prevail. But as regards the PMLA is concerned and the IBC is concerned, we have several case laws, and no one has given any verdict that which one should prevail. Because the main purpose of the PMLA is altogether different from the IBC. Under the IBC, we are looking after the resolution of the property, resolution of the city, and once the resolution of the city is there, whoever is the creditor, they should get the money and the company should go on. Whereas under the PMLA, the basic reason for the PMLA is to catch hold of the person of the criminal who has done all the wrongs. So there are two things under the PMLA. One is the criminal activity. The another one is the recovery of the money. So there are things which are altogether different from PMLA and IBC. Since two different aspects are there, two different outcomes are there. So no one will be prevailing over other. That has been made clarified by many courts. So now I am coming to case laws. There are several case laws. Number one is if I'm coming to one of the case law is Varsana Ispat. It went to Supreme Court. The similar things were there. The attachment was there from the ED, and then it went to IBC, and under the IBC, the RP contended that since the IBC started, then Section 14 should be prevailing, and the moratorium should be there. And once the moratorium has started, whatever assets has been taken custody or taken control by other person, that should be vacated. Supreme Court made clarification in this on this judgment that the PMLA is altogether different aspect, and the IBC is altogether different. So Section 14 should not be applicable in case, and attachment will prevail. So it was clearly mentioned in the case of Varsana Ispat that attachment should not go away simply because the liquidator or the RP has taken charge, and Section 14 will not be having impact. So in that way, Section 14 has been negated by Supreme Court. Now, one more case we have seen in the case of PSL Limited versus Nitin Chen. In this case, Nitin Chen was the liquidator in the company, and he went for the liquidation, and the liquidation process started. Even the auction process was completed. Not completed. Even the auction was completed, but the revenue was not received. Whatever the sale value was there, partly it was received, partly it was not received. By the time part amount was received, the ED made attachment for the PSL Limited. And of course, once the ED attachment is there, Nitin Chen went to the NCLT and other courts. But again, there was no outcome for this one. The only outcome which came from NCLT, thereafter it went to High Court also. It was asked by the court that the liquidator should sell out the property. Whatever assets are there, all the sale should be there. And once the sale is completed, how it has to be dispersed, that has to be looked after by the High Court. This is the outcome of NCLT, that it has to be decided by the High Court on. What High Court has mentioned, it has mentioned that you have, and of course, by the time High Court it went to High Court, there was a agreement between the liquidator and the other person, along with the ED also. And the amount of the ED, the amount of the proceed of crime, as per the ED, was approximately 270 crore, whereas the amount which has to be recovered, which needs to be recovered, was much higher amount. It was approximately 450 or something, 450 crore plus. So what it was mentioned that you sell out the property, and it should be kept with you till the final disposal. Then liquidator filed one case again with the court that whatever excess amount is there, let me disperse that amount, and whatever 270 crore is there, which is the requirement of the ED, and it has been claimed to be the proceed of crime, that amount can be kept in the escrow account, and once the decision will be made, thereafter the disbursement will be there. And it was also accepted by the ED, and both submitted the same thing before the court, and court allowed this one also. So in that way, part disbursement of the amount was allowed in the case of PSL Limited. There are many judgments, and all the judgments are having conflicting views. Lately, on 1st of March 2024, there was a Bombay High Court judgment. This judgment is the final one as of now, because the judgment is of the Bombay High Court, and it will of course be traveling to the Supreme Court also, and let's see what is the outcome of the Supreme Court. But as of now, this judgment is the final one to all the RP or liquidator hearing. But what this judgment is saying, this judgment is clearly saying that once Section 32A is there, this Section 32A is very much clear in its terms. Number one is whether the liquidator or the RP can approach to NCLT for deattachment of the assets or not. So it is well within the powers of the NCLT to provide a judgment to attach or de-attach the property. So this is the it was the conflicting area where, because on many occasions we have seen NCLT has passed the order that you have to de-attach, and thereafter and ED made the argument before the court that since I have started the attachment before, even prior to the CIRP, then how should I de-attach? And there were conflicting judgments for that one. Now the Bombay High Court has given that NCLT has the power to order for the de-attachment provided Section 32A is applicable. So what is Section 32A? Section 32A is speaking about that once the CD has got the resolution plan, and this resolution plan has been approved by the NCLT under Section 31 of the IBC. So once the resolution plan has been approved, there are few criteria in Section 32A whether the resolution plan has been approved or not. If it has been approved under Section 31, 31 is saying that all the IB code criteria have been met or not. And one particular thing is there, whether the plan, if it has been approved, then will it be having on its own, it can continue as per the plan or not. So if someone is taking over a CD and by way of resolution plan and is making a future planning person, that I will do the case take the case in such a way, then whether that is possible or not. So that has to be seen by under Section 31. So whether that resolution plan has been approved or not, and thereafter whether this management, whatever the management is there, whether it is a new management or not. There should not be any linkage with the old promoters. There should not be the old promoter. There should not be the key person of the earlier promoter, and there should not be a related party to the earlier promoter also. So if these conditions are fulfilled, thereafter in Section 32A subsection 2, again it has been mentioned for the liquidation also. If the same thing is there, but if it is sold under liquidation, if it has been sold to another party, and if that person is not related to the promoter, then it can continue. 32A is applicable, and assets should be passed on to the new promoter under clean slate position. So this future case, it is in that way that if 32A is applicable, then all the criminal activity or all the cases against the CD should be discontinued, should be wiped out, and under a clean slate, the CD should go on to the new promoter. The only thing is, if any criminal activity is there, other than the CD, against the promoter or against another company, then it should continue. And I think RP and liquidator are not bothered for other things also. So as far as criminal law is there, criminal actions are there. Criminal action will be against the promoter. That should continue. But civil action or the whatever criminal action is against the company or the attachment of the company, that should go away. So that is the outcome under this one future case, and this criminal action should continue. It was also mentioned in High Court of Delhi on 13th of March 2024. It has been clarified in the case of Mr. Talib Hassan Darwesh versus Department of Directorate of Enforcement that if the criminal action is there, that should continue. So these two judgments are there, which are giving very much clarity what should be the outcome of a case where the PMLA case is going on. So the PMLA is the only one law which I am referring to, but there are several other laws which are equivalent to PMLA. Like economic offense wing of every state is there. In the Maharashtra also there is a Maharashtra economic offense wing. In West Bengal also there is a West Bengal economic offense wing, and there are several laws. Like in West Bengal there is West Bengal protection of investment of chit fund depositors. There is a law. which has been looked after by EOW. They are all these laws are having similar sections as if it is in PMLA law. So whatever the outcome of the PMLA, whatever the consideration of the PMLA, we can consider that similar other laws will be dealt with in that way only. So it all started in the case of JSW Limited, wherein Ocean Steel acquired that plant, and once the plant was acquired by the Fusion Steel, and the amount was partly paid, and it was going to be taken over by the company. At that point of time, it took over attachment, and it started attachment and took over the custody of the property. Then it went into court, of course, and thereafter only, considering this particular case only, Section 32 capital A was inserted by the IBBI and of course by the government, and it was notified also in the month of December 19. And considering this particular case only, Section 32A was there, and major relief has been granted for all the city cases. There were many hiccups in the case also, because once this 32 capital A was there, ED claimed that it should be prospective in nature, it should not be retrospective in nature. But finally, looking after the merit of the case, it was given the judgment was given that whatever 32A is there, that should be applicable in that judgment also. So that is the way things are there. Now, if we go through the practical approach, practical aspect, how should we, if a company, if a city is there, wherein I am the RP or I am the liquidator, then how should I proceed with? Because I have seen many cities are there for which CRP started in sometime in 2017, 18 or 19, and the case is still going on. Even after 4 years, 5 years, 6 years, the things are still pending. They are pending due to legal issues, either at the anklet position or at the Supreme Court level. Under the Supreme Court level, there are many, I think 9 to 10 cases are clubbed together, and the judgment will be given at one go on. So as far as IBC is concerned, as far as the RP and liquidator is concerned, how should we approach? So after going through the Shiv Charan case, what I can see that without going into the further detail, if we approach to the NCLT, and if we go for the EOI, expression of interest, if we go for a resolution plan, and we confirm the SRA that Section 32A is giving you a free handle, you can de-attach the property, you can enjoy the property, and it will be going to you as a clean slate. And even the judgment is there, the SRA, whoever is the SRA, they are more equipped than the RP and liquidator. They will also look after the thing, whether if the company will be taken over by them, and the resolution plan is implemented, is approved by the NCLT, all the liquidation, under liquidation, the sale will be there of the company as a going concern, or the assets will be sold out to them. Then of course the ED attachment will go. So if we go by that way, if we go by the approval of the resolution plan or sale of the property, thereafter, if we approach to the NCLT, then NCLT will be free to announce that assets should be de-attached, and it should be free from all encumbrance, and ED won't be having any power on that one. Of course, we'll be waiting for the Supreme Court judgment also, but that is one of the aspects wherein we can go ahead. Now, second aspect is if we can have a tie-up with the ED officer also. Of course, if they come to a conclusion that there are certain aspects in that way. Like in one of the case, like I have mentioned in the case of Nitin Chen, wherein ET was saying that my attachment, my proceeds of crime is X amount. And if you can confirm that X amount will be given to me, then I don't have any trouble for that one. So instead of giving a confirmation of passing of the amount, you can place the amount to an escrow account, and let the final outcome be there. Whatever is the final outcome, on the basis of that outcome, that amount will be going either to the ED, or if the outcome is in favor of the financial creditor, it will be distributed to the FC or under section 53 of the IB code as per the outcome of the judgment from court. So that is one. Number two is, if we can provide like in many of the cases we have seen, FC has taken mortgage of the property before giving loan. Like someone has taken loans in the year 2015, and thereafter the company has started the business. And in the year 2018 or 2019, the loan has become NPA. And the money laundering activity was claimed sometime in the year 2016, 17, or 18, but after the company started. So in the case of FC, whatever assets they are having, all those assets were procured prior to the start of the business, prior to the time when the crime was actually taken up. So if there is no proceed of crime is there, because whatever proceed of crime is there, that has gone somewhere else, but not with the FC's property, because these properties were acquired prior to the crime. So if we can have a agreement with the ED, like I'm looking after one of the case wherein I've spoken to the bank also, and the ED has agreed that if you give me in writing, if you if you agree on the terms, that if any process of crime is there, that can be proved that this is the process of crime, and by this process of crime this asset has been created, then this amount will be given to me. And the bankers are actually going into that one, and if that being the process, then the outcome will be there. Of course, the bankers will have to take a call, and I think bankers are also aware of that. If they don't take a call now, then the matter will be going on for years together. And of course, they are also taking a call for that one. So this is the practical approach what I have seen. I can see now. I will be looking after what Makija ji will be speaking on this aspect also. Now, one major issue what I have seen is facing the ED official. Once the insolvency case starts and the RP or the liquidator takes charge and the attachment is there before the ED, then the ED of course call up the resolution professional. He calls the liquidator, and he look after actually I can say that he inquires about the CD as if the RP or the liquidator is the promoter itself. Whatever crime was there, that was done by the RP or liquidator. So actually I have seen in one of the case there was a harassment to the RP and the liquidator. Of course, there won't be any outcome for that one, because RP or liquidator came into picture once the account became NPA, once the fraud was there, once the money was diverted somewhere else or invested somewhere else. So it was not the fault of the RP or liquidator, but ED they don't believe into that one. They look after that you are in charge of this company, so you must have some thing into that one. So how to face the ED? How to face the CBI? That is one of the major aspects. So what I can gather from my own things. I have been called by Enforcement Directorate, and I have been questioned in the same way. So I as a liquidator or the RP, what is my lookout? Means what I have to see. I have to okay. So what I have to say, since we are doing the work as a court officer, we are doing the work under the IB code. We should not be having any fearing approach. Number one is whatever has been asked by the ED or the CBI, we should provide all information which is there in our custody, for which information is there with us. We should provide each and every information, whatever is there with us. there should not be any. They will like to intimidate you. They will like to say you that you accept this one and will otherwise will do something. But you don't. You have to accept only the thing which has been done by you. You should not be accepting anything under pressure. If you accept something which is under pressure from the ED or CBI then you will be at mercy of them. So you don't accept. You don't have to worry for anything. You just have to see whether whatever work I have done, whether it has been done diligently or not, whether I have done all the things with transparency or not. If everything is there, even if certain mistakes are there, you can simply say that these are required to be done. I have done this one. This is my mistake. So it is in a total mistake. So we should not be worried for that. Once everything has been mentioned, everything has been clarified by the RP of the liquidator. Of course, they will be they won't be having anything against the RP of the liquidator. They also know that promoter is the actual culprit. ED, CBI, whatever other person is there, they know liquidator and RP will be providing only the information and nothing else. Of late, only in the last month, I have seen ICI has issued one circular. In that particular circular, they have given how to behave with the chartered accountants by the investigating agencies. So I'll be sharing that circular with all of you, and I'll be sharing in the group also. In that particular circular, it is very clear. It is very clear for the investigating authority. If you are calling any chartered accountant for any purpose, first of all you have to provide every information which is there with you. You have to mention what is the actual reason for this one, what is the requirement by the ED. Those should be provided only when the chartered accountant is not providing you the information, or you come to a conclusion that chartered accountant is a culprit, then only you start with the interrogation and other things. Then also a media person should be there. Then also whatever steps you are taking, that should be in a fair way. Whatever is legally there, those actions should be taken. Although I know but I can see that ED won't be having so much detail about the circular. They won't be going to that one. But of course, once the circular is there, it will be providing you some relief, and you can always show to the department that these are the this is the circular which has been given by ICI, and I'll be providing you all the information. And if possible, you adhere to that one. Of course, you don't have to argue with the ED officer on your own terms. You have to be cooperative at all times with the officials. So with these, I conclude my session here, and I'll be happy to provide you all the participate in the question and answer session. So hand over to Vivek Charanaji.
Thank you, Binayji. So first of all, I will request all the participants to please open your videos so that we can interact in a better manner and we can see our faces. The moderator will find it easy if he can see your faces. So I now request Mr. Mahesh Chandra Gupta to moderate the question answer session. Mahesh ji.
Okay, thank you, Vivek. I thank both the speakers, very well deliberated. Now it's the main thing, question answer session. So first I would like to take the questions which have been put up in the chat box. So I'll take first question which was put up by Mr. Sivanandan Sharma. I think this is to Mr. Kama. RP has no funds and has been unable to pay salary, wages, including TDS and PF, for months during this CRP period. As an abundant precaution, I have filed the PF return before the 14th of each month with admin charges of 75 only from my pocket. I have written to the EPF department that I will deposit PF as and when salary wages are paid and requested a waiver of liability under section 7Q 14B. All employees have confirmed and signed this letter requesting 7Q 14B liability waiver as a special case. It is proposed that the RA, if any, will meet the 7Q only. What is your view on this action by the RP?
Sir, can I?
If
Can I answer, sir?
yes, please.
Sir, actually, if no wages have been disbursed, so there is no liability towards Provident Fund. If he is not able to pay any wages during the CIRP, he is not liable to pay any Provident Fund on that money. There is no liability on him to pay any of those dues. But for the pre-CIRP period, if any dues are there, they will be paid in priority. If he is not having funds, there is nothing he can do. Second, there is no provision where members can ask for waiver of interest or damages. There is a provision for which there is a long run provision where one needs to go to the NCLT, get a recommendation, and then send a request to the Central Board of Trustees for waiver of damages. Interest, there is no provision for waivers, sir. Only damages can be waived. That too, if you go through the entire process. So if he is not having funds, he is not paid salary, no liability. I don't think he was even required to pay the administrative charges. It was not required for him to pay.
Just to add, sir, here, he should not have filed a return also.
Yeah, of course he can file nil returns. If there are employees and if he has not paid, then why has he filed the returns? He could have filed a nil return. He need not have paid anything. He need not have filed any returns also. Not required.
No, as per his question, I believe there are employees and he has just filed the monthly returns.
Then he can
say that. So I think that was not a good thing. Mr.
Yeah, sir, he should file only if he has paid salaries and PF has become due.
Correct. Mr. Sharma, you are there? I think he's
I hope
not
Mr.
there.
Sharma is able to listen. Okay.
My view is, and we are getting letters from PF that when the registration is on, even during my liquidation process, I am getting a registration cancelled. So I have been directed to file monthly returns with 75 rupees administrative charges. Our view is that as an abundant caution, we must file returns on or before 14th, even if there is no employee, and we should pay, and we are continually doing it for all other companies also.
Nil returns, yeah, you can pay, but as an officer of the organization, though they ask you, but once the establishment is not functioning, if there are employees, yes, nil returns have to be filed. If there are no employees, what I said is no employees and no salary has been disbursed. If employees are there, salary is not disbursed, there you can file a nil return saying that no salary disbursed.
But we are as an abundant caution, if no employees, nothing, as the registration is continuing, we are filing nil return with 75.
So you can ask, sir, if the company is closed, is it closed, sir?
No, I mean one process in a liquidation process where there is no employee, I have been advised in writing to file nil returns with administration charges by the department.
No, sir, it's not right. You can get the establishment master recorded in the establishment master. The company is closed under liquidation.
I have asked for cancellation of the registration also. I said, why?
Yeah, it will be done, sir. It should be done, and you don't need to pay.
Because it is not a big money. It's a 75 rupee monthly. So we are.
It's not about money, sir. It's about you continuing that company. Why? Company is closed. Get it recorded as closed. Get that. Follow up with the regional PF commissioner and get it closed. In the establishment master, it should shown as company closed. I got it done for some voluntary liquidation case. Some of the liquidator asked me for assistance. I got it done, and it was immediately it was done, and I was able to share the requisite order. It can be done, sir.
Okay, sir. We move to next question. It's
Sir,
by
in
Mr.
this, I just wanted to add, can we do that during the CIRP also if the company is closed and there is no employee?
Yes, sir, you can
Can
do it.
we can
Yeah,
get
sir.
the master? Okay,
Yeah,
okay.
you can
Thank
get it.
you.
You can get it done.
Thank you.
Next question is from Mr. Srinivas MP. PF claims are coming after 450 days of CIRP. Is still SRA liable to pay even though employee not traceable?
Sir, one thing is that if money is due, money is to be paid. And now, as a liquidator, who's the custodian of records, sir? Is the liquidator. It's a liquidator's duty. Sir, let me complete. Liquidator's duty to identify the employees. But if he's not able to identify, we have to pay the money and ask for records from the Provident Fund based on the records available with them. For those
Hello.
employees, the returns have to be filed.
So, sir, I think question is for during CRP
Date of
CRP
appointment.
period, and he's saying claims are coming. So claims are coming. So claims either it will be in the claim form, then it will be dealt with as per IBC law, and if their demands are coming out, then he can. I think RP can always write him to file a claim.
Yes, sir. They have to file a claim. PF authorities have been instructed across the country to file their claim, sir.
May I ask
They
a
have to
question?
file a claim.
Mr. Mahesh, may I ask a question?
Yeah, please,
Yes.
please, sure. Your good name,
Yes.
please?
Sandeep Chitkara.
Yeah, Mr. Sandeep.
So, Meji, so in one of my CIRP case, actually I have got a claim of 4 crore 85 lakhs from PF department. But the thing is that, yes, we are communicating with the PF department, and we have asked for the details of calculation of this very claim. Moreover, maybe whatever implies actually details are there. So on what basis actually this claim has been calculated. So nothing is provided as of now, but PF department again and again is claiming that this is actually something which is a best judgment assessment on their part. And this has been calculated because so no records have been provided to PF department. Accordingly, this claim has been calculated. But as of now, despite numerous communications, we have not got any kind of maybe a calculation sheet or maybe the list of employees on whose basically basis this very claim has been calculated. So no such document. And I know that there is some jurisprudence involved here. So wherein actually courts have instructed PF department to provide details on an employee basis rather than just a total aggregated claim to the RP.
Sir, yeah, there are judgments and there are instructions that identification of beneficiary is one of the primary requirement while assessing the dues. What happens is in such cases where records are not available, if you are the custodian of the records, they will shift the blame on you, saying that you are supposed to be the custodian of the records, you provide the records and we will assess the dues as required. If no records are there, normally what the department does is they take the last filed return, last available details, and based on that last amount paid, they multiply into the number of months for which the dues have been calculated. But however, for the last month which they have taken into account, there would be details available with the department and they should be able to provide you that so that they will enable you to file the returns for that. Without that, you cannot file. Unless you have the names, you cannot file. And paying the money without return is like putting a money into it goes into a suspense account. It does not go to the members account for which the provision is there. So if at all money is available and you're paying money, you need to get hold of the PF department, they will have the details of the last based on which. And one more thing, at the time of assessment, the assessment has to be done on a month-wise basis. They have to give you month-wise assessment. Number of employees and amount. Month-wise, they have to provide total wages during the month. If it is the same month, you take the list of employees on the last available date and pay for them. That's all. They could not be new names. They would be the same names.
Okay, sir. So you rightly said that actually they will ask for records from our side. So you rightly said that. But the thing is that on my part, actually, I have filed one 19 Supper 2 application of non-cooperation from the erstwhile management. So there are no records available as of now. And moreover, can I ask for some kind of maybe judgments? Can you just let me know the certain judgments or maybe a Supreme Court judgment, so which I can quote to the department and pacify
So
them?
there is only one judgment. It was in a builders association case, but that's negated because they use the adverse inference. They say that you are the custodian of records, you don't provide the records, and now you want to take advantage of it. So department does not agree with that. What the best given solution is, the PF department can provide the details of the last number of employees on basis of which they have assessed, and for those employees the returns have to be prepared and filed.
Okay, so that's why, sir, I have kept this claim under verification since last 4 months now. But
Sir, have they given you an assessment order, sir?
Sir, no, actually, there is one order from their side. So, but the thing is that no employee-wise details are provided.
Employees name. Sir, do you have an order passed? Do you have an order passed under Section 7A of the Act? Have they given you an order passed under Section 7A of the Act?
Yes, there is one order passed under Section 7A.
Listing month-wise dues?
No. So,
You ask them to provide you month-wise dues. They are bound to provide you month-wise dues, sir.
Okay, sir. So they are
bound to provide you month-wise dues. They are also bound to provide you the last. If it is an ad hoc assessment based on the last list of employees available, they have to give you the list of employees for that. You can write to them, sir. Which office, sir?
Okay, sir. I think time is very short. There are many questions. So can I move to next question?
Yes, sir.
Mr. R. Hariprasad has raised one question in the chat box. During liquidation, there are PF claims and liquidation expenses. When realization profits are insufficient to meet any of them, which one shall get priority? Liquidation expenses or PF claims?
So, money realized from sale of assets, sir? Is he having realized from sale of assets?
Yeah. I mean, he means to say that only.
Yes, sir. Sale of assets.
Yeah, sir. He can adjust the CRP cost and balance only to be paid to PF. The reason is, whenever we sell any property of the asset, the cost comes first. Here you have sold the asset, cost comes first. The cost has to be recovered. If there is money available beyond the cost, only need to be paid to PF, sir.
Okay. Next question from Rajesh Kamath. Whether water dues, pre-CRP and property tax of MIDC leased property is covered under Section 32A. I think this is an irrelevant question for this topic. But if any of the speaker can answer, fine.
I don't know, 32A which?
Section 32A is very, very clear. It is only for the purpose of PMLA versus this one or any attachment by any other department. So this water dues are not in, actually it's not required to be covered therein, because you can simply approach to NCLT for waiving any dues, and they will be pleased to provide you provide a benefit to you. So no due will sustain in the NCLT. So rest assured, and we have many judgments for that one, and even the clean slate judgment is also there. So it will be there.
Okay, thank you. Okay, thank you. Mr. Ravindra Beliar has given some observation to Mr. Kama. I'll just read out. On the SC judgment in the context of earlier Companies Act gave priority to PF with reference to livelihood requirement. If this is limited to workmen's PF dues, it is somewhat understandable. If the priority of PF dues is for employees also who draw the highest salary, more so even to the MD, that too for a period of more than 4 years, the blanket thinking about first priority defeats the objectives of livelihood and the objectives of IBC 2016. Second point says, I am fine if Section 53 especially includes 53 dues at the top of the waterfall. but an interpretation of not part of the liquidation estate does not make sense. When a gratuity PF funds are maintained separately, then it is fine. But when there are huge dues towards PF in a city's account, and when such huge liabilities to be paid from city's liquidation state, it doesn't seem to be logical. If the
So that is the law, sir. That is the law of the land, sir. Sir, how I feel is not the criteria, it's the law of the land. Law says you have to pay, you have to pay. I may not agree with the law, but if the law says so, we have to pay.
Correct.
It's Supreme Court has held it, sir. Can I sit over the judgment over Supreme Court, sir?
Okay. I think these are all in the chat box. Now I keep open to anybody having any question to either of the speaker. They can say, Mr.
I have one question, sir. Yeah, I have one question with Mr. Narayana. So, in one of my case, there is one liability before the commencement of CIRP of PF, which is a running liability. Normally, any liability claim to be filed. In that situation, whether we should pay the PF liability pending at the commencement of CIRP first before making any other payment of salary or other dues, or
Sir, if you have money, if you as like any other claim, it would be paid on priority, sir. It has to be paid first, and then only you can go to anything else.
But the claim has not been filed. Claim has not been filed.
You can ask them to file. If they have not filed a claim, you can. But if the books, sir, there are sometimes what happened, there could be liability shown towards Provident Fund in the books of account. In that case, based on that, you can make the payment, sir.
And second is whether any pending litigation can be adjudicated after the commencement of CIRP?
Yes, sir. If it is regarding assessment of dues, yeah, at any stage, sir. There is no bar no bar in conducting an inquiry for determination of dues, sir.
So, but in my case itself, the NCLT has given the direction order. The liquidator have right to initiate the prosecution against the arraigned officer who has done the adjudication after the commencement of CIRP.
Wrong, sir.
But that bench may be wrong, but I'm just telling you the actual case.
I said that they have a right for assessment, sir. Enforcement is different, assessment is different. Assessment can be done because they have to determine the dues employees what is due. For that, records are with you, they can summon you. You have to attend the inquiry, produce the records if you have. Based on that, they will give you an assessment order. Assessment is not barred, sir. I don't know under what context the NCLT has given that order. If there are orders that he should be prosecuted, I don't know how it can be done.
One question, sir. One question I have. Sir, may I ask? May I ask, sir?
Just wait 1 minute, please. Mr. Pamecha has raised hand for a long time. So let Mr. Pamecha raise his question.
Yeah, thank you. See, my question is with regard to the submission of the claim. See, I observe in some of the cases in mine also, PF department sometimes submit the claim even after the approval of the plan by the Honorable NCLT, or sometime after the approval of plan by the COC. Now the question is whether these claims submitted after the approval of the plan, whether these are maintainable. If yes, who's going to be paid? Because the successful resolution applicant want this company to be clean company. He are not bound by the action or some action taken by the previous management. So whether these claims are still maintainable, the question submitted after the approval of the resolution plan or after the approval of resolution plan by the COC pending adjudication by the NCLT.
Sir, Jet Airways claims what it says that if there is no provision made for the claim for the amount of provident fund, SRA will be held liable.
That is why
that will be against the object of the code, because see the resolution applicant, he is not knowing, even the RP is not knowing whether they're in claim, because PF department has not submitted claim on time.
Sir, PF department has to submit claim. If they are not submitted, there's a process for that. You go ahead with that process. But any amounts which are lying due towards provident fund, sir, just now I read out it, I gave you a judgment of the Honorable Supreme Court, which says that Section 17B, which is the continuing liability for the new management for any dues prior to his taking over, he is jointly and severally liable. That's what I very categorically said. The object where we
see, whenever the plan approved, see, the anything which is not
Agreed.
provided in the plan, the liability get extinguished. That is the provision of the code only.
Yes, sir, but non-abstanta clause of EPFO overrules your 238. Then how do you say that you still have the
In that case, the resolution plan will definitely going to fail because the resolution applicant is not knowing and even RP is not knowing.
Agreed, sir. You get an order from NCLT that the claim is rejected.
No, it is extinguished after the approval of the plan by the NCLT. Anything amount is not part of the plan is extinguished only.
If they have not submitted
They have not submitted the claim after the approval of the plan only, not the before the approval of the plan. After the approval of the plan, RP has rejected because the RP has not found by the claim which you have submitted after the plan is approved by the NCLT.
Sir, I got your point. Sir, after the approval, if he has filed a claim, he has to go to NCLT and get an order from NCLT to ask you to accept. No, don't accept till the NCLT gives you an order.
Once the order of approval of the plan, RP is discharged from his duties. He has no power to admit the claim. Who will going to admit?
Sir, then leave it. No, you're not. You have done everything. Your job, you are discharged. You leave it. Let us see how the law plays around. Sir, the question is, as the law stands, sir, one thing is, sir, please don't treat me as a Provident Fund Department man. Don't say that I am trying to advocate on behalf of Provident Fund. Sorry, sir, no. I am not. I am only trying to present the position of law. It is for you to accept or not.
No, sorry, sir, is a healthy debate going on. Nothing to.
Mr.
My discussion only, the jurisprudence will come. It is healthy debate, sir. We are definitely with you, sir.
I agree, sir. I also do agree because that particular judgment which says that claims don't get extinguished is not a fair thing, because after the plan is approved, plan is implemented, somebody comes with a claim, Section 17B being invoked for making the SRA to pay the money is not in continuation of or not in support of the objects of our code. Agreed. There would be, going forward, there would be a case law on those things as such. I hope. Right now, the 17B
there is a corollary. In this corollary, in my particular case, the CIRP is over, but the liquidation order is not yet passed. And now they are coming with 17 damages and all that notice that they want to adjudicate it. So what is my stand now?
You will have to appear before them, provide the documents. If the damages are liable, they will issue an order. And go. If there is a damages order, if you have funds, you will have to pay them on priority, sir.
Okay. And
Mr. Ravindra Belwar is raised as hand.
Yeah, yes.
Belwar, just come up.
Yeah. Mr. Narayan Kamma, I got one very good insight during your talk. That is that in case the amount is not disbursed, so there is no PF liability. That is what I understand. So extending that logic, supposing in a CIRP, in a successful resolution, if the SRA has allocated, say, 5% of the, I mean, it so happens that if the workman dues are, if it has to be paid on par with the secure creditor, it comes to only 5% and he has allocated only 5%. So the PF dues also will be in relation to the whatever is disbursed, or then the PF will be PF has to be paid full. So extending the logic what you said disbursed, then I take it that it will go.
Sir, if the disbursement has not happened, there is no claim from the Provident Fund Department for that period by an ad hoc assessment or some assessment. If you have, there cannot be an assessment because salaries have not been disbursed. So if you are going to disburse only 5% of the salary, on whatever you disburse, only PF will be paid. It's very clear, sir. Based on what disbursement? It is not what, yes. Unless he gets the salary, he will not be liable to pay PF.
Okay, thank you very much.
Mr. Sivram
This is
Prasad.
Ravichandran.
Yeah.
Can I ask one question, sir?
Ms. Narayan.
Ravichandran, sir, here.
Mr.
Actually,
Ravichandran, just hold on,
yeah.
please. Mr.
Sir.
Sivram Prasad.
Yes, sir. Yes, I am here. Question to Mr. Narayana, sir. See, sir, during your presentation, you were always referring to PF, but at the end of the presentation, you have included gratuity also. That means even the gratuity, the same terms of the PF we have to follow?
No, sir. That was as per the judgment. I am not talking about gratuity. I only in that judgment both were covered. That's why I have referred to that, sir. The particular judgment covered both gratuity and PF both.
Okay,
The judgment
Mr.
covers gratuity as well, sir.
No, but I think this was only some NCLT judgment, right? Or gratuity is also included in Supreme Court judgment.
I think it's there in this. I need to look at the judgment, sir. But it is judgment. Gratuity is also part of that. I think it is what you call. There is a judgment, sir. It is there. Supreme Court judgment is there. But there, everybody comes up with a interpretation saying that unless a fund is created, he need not pay. Sir, in Jet Airways, sir, I think in Jet Airways it has been said that you can look at the Jet Airways. It's a Supreme Court judgment where the gratuity is also part of it.
Okay, let me see. Okay.
It's a Supreme Court judgment, sir. We cannot say no.
Okay, Mr. Ravichandran, please.
Yeah. Sir, actually, in one of my cases, what happened is that the S2L management had not remitted the PF for last 3-4 months. And with the result that the employees are not able to withdraw their PF. So, I mean, is this the law or
how does it matter, sir?
Or,
sir, it has nothing.
What happened is that the earlier management did not pay the PF for 3 to 4 months actually before commencing of CRP. With the result, the employees are not able to withdraw the PF. When we approach the PF authority said that you make the PF up to date.
Sir, there is no such law, sir. There is no rule. Proportionate to the amount of balance available in the accounts, the department is liable to make a payment. Just because there is a default of 4 months, they cannot stop members from withdrawing their money. No, sir, the department is wrong there. They have to pay the money, sir, irrespective of the default, to the extent money available in the account.
Okay.
To the credit of individual employees, they have to pay.
Yeah, whatever money is available to the credit of the member, they have to pay. They will pay the balance as and when the amount is paid.
Sir, one more question.
In my case, we argued actually, but then, the department was very adamant. They said that you have to make the payment for 4 months. Then we took up the case to COC. COC gave the approval to make the payment to department. We paid to department, then only, we could help the employees. This was the case in Chennai.
Not necessary, sir. Not necessary, sir. I have got payments done for certain people where the payments were not there. There was a default amount. They were withholding death cases. Then when we took up with the department, all the cases were settled.
Thank you, sir. Thank you.
They have to settle, sir. It has nothing to do with the default.
That's a question
to the
adding
extent
to this.
Balance available, the department is liable.
Sorry, sir. Question adding to this. In one of the case where the dues were recoverable of 2006 onward, and the employee was struggling to recover their money from the PF department. The PF department is insisting that all the documents should be provided by the company. The company is closed since 2012. There is no document available. And the liquidator is not in a position to provide any of the information about the employee. And on that ground, they have holded the PF and employees are still struggling for that.
Sir, have you paid the money?
Yeah. Money is being paid. Money is in their account. Just because the documents are not available in the company.
What document you need, sir, now? Please let me come to you, sir. What documents are they asking for? What documents?
They need the proof of the employment and all these.
Nothing doing, sir. As a liquidator, are you comfortable in certifying that these were employees of the company? Are you? Can you certify that they are employees of the company?
No, because I don't have any record. Because they are talking about 2006 to 2010, the company is closed in 2012. I don't have any record then. That is
Sir,
the
how
problem, sir.
then you tell me how the department can pay money to anybody who's not, sir, either the company has to identify or as the liquidator has to identify based on whatever records he has.
Okay.
Unless the person is identified, how can I pay money to XYZ? How do I know he was the employee? Some record to show that he was an employee.
But in the PF
And
department,
once you're sure that he was an employee of the company, you ask the employees themselves to provide some record to show that they were at some point of time employee based on their Aadhaar and others. It can be done. But unless you're able to identify, because it is your responsibility as the employer to certify that they were part and parcel of the company.
Okay, okay. Thank you, sir. Thank you.
Yeah, Mr. Sharma, we can take two more questions because we are overshooting now our allotted time. So, Mr. Sharma, you have raised hand. So please be very brief.
Mr. Kamma, everybody is coming with one point that after the COC approval, the department is haunting them with claim filed after COC approval. Justice Chandrachud has given a wonderful order in Balbir Singh versus Union, and we refer to PF department that you go against the erstwhile promoters. Is it not the right stand for us?
Sir, as far as claim is concerned, you are very well within your right to reject the claim. As far as PF department's right to enforce against the erstwhile directors, they have every right to proceed personally against the erstwhile directors. They have enough powers. They can arrest the erstwhile directors, put them behind bars to get the money. So as far as you are concerned, sir, if your COC is not approved, the plan is approved, no claim has come, you're clear. If they make a claim after that, you said, my job is done, I'm no longer associated with this. If you want to recover, you go and recover, exercising your powers under the act. They cannot come against you. They have to go against the erstwhile promoter or the subsequent SRA. It is for them. SRA will protect himself, saying that whatever the Supreme Court judgment which says that the claims are extinguished because there was no claim filed, I think we should be able to, the SRA should be able to protect himself.
Okay, thank you, sir. The last question from Mr. Vikram Kumar. I'm sorry we cannot take any more questions after Mr. Vikram Kumar because we are already.
Thank you, Mahesh. Sir, I joined a little late, so kindly excuse me, if I am repeating something. My humble question is, we all aware about the challenges of handling this in PF and pension and gratuity dues, because post-approval of the plan, the courts are ordering the SRA to pay the dues. What is the best way, the RP should handle this issue in a way that he can successfully, close this whole process without getting into all these litigations?
Sir, litigation for RP ends once he has handed over?
No, so my point is, sir, after the approval of plan, the court is passing orders for the SRA to pay, as a result of which the plan is not getting implemented and all these challenges are happening around this issue because nobody is concerned about the fund. Everybody, the Supreme Court also says no fund business. The dues of employees has to be paid in full by the SRA.
Yes, sir.
So how do you handle this issue? Every RP is grappling, sir.
Sir, simple. If you have money, pay. If you don't have money, if there is a plan, sir, if you have received a claim before the plan was approved, you are clear. If there was no claim, plan is approved both by COC as well as by AA and plan is implemented, then you are safe. You are out of picture, sir. It is between the department, SRA and the erstwhile directors.
No, I agree, sir. But ultimately,
sir, somebody would go to court, sir. Somebody would go to court quoting the Supreme Court judgment saying that claim gets extinguished if they have not claimed. If they have not claimed, it's the department's fault, sir. Departmental instructions are very clear that they are supposed to file their claim before the department. If they have not filed, it is their mistake, sir. You can write to the head of the office saying that this is what the officer concerned, whoever has slept over the matter, is responsible for that. He should have filed the claim before the COC, once the public announcement came or subsequently as and when it was notified to him. If he has not filed a claim, he is personally responsible for that. We will go by the law stating that all claims get extinguished once the plan is approved and implemented. Of course, section 17B, one of the judgments says that 17B, both the previous employer and the subsequent employer are part and are jointly and severally liable. But SRA has, this would be a point of litigation if the amount is very high. Normally for small amounts, the department may not proceed. But however, it's a gray area which needs to be adjudicated upon, sir.
Thank you, sir. Thank you. Now we conclude this session. It was a wonderful session. And I feel, and most of our friends feel that PF, this subject is such a vast that there are many unanswered questions. And we need a full day discussion on this and to come out solutions for various real problems which we are facing. Even SRA who has come, as we rightly said, although we are not responsible after plan approval, but still SRA will look on us as RP, why you have not sold and why this was a problem which were coming. So naturally we'll have to come out with some solution and some suggestions, not solution we cannot say because after Supreme Court judgment, another judgment, we don't have any solution. But certainly we can come to a SOP sort of thing, how to tackle these problems. Thank you very much, Mr.
Sir, here only one small point, sir. What I said is more often than not, when the department comes up with a claim and belatedly, department will not be able to identify the employees. So it will be very difficult for them to enforce their claim as they go forward. Yeah. They need to identify the member and saying that such and such member has been deprived of his benefit unless to enforce their claim, sir.
Thank you, sir. Over to Mr. Vivek.
Thank you, Maheshji. Thank you, Kama, sir. I request all the participants to please stay connected for a few more minutes. And next, I invite Mr. Sandeep Chitkara to make the announcement of the next webinar of IPNet. Sandeep, sir.
Yeah, thank you, sir. Thank you, Vivekji. I'm delighted to share that IPNet North is organizing one webinar on 7th of December. So the topic is challenges and solutions in the case of cross-border insolvency and group insolvency. So one of the speaker is Dr. Risham Garg. So he is professor in National Law University. So and other speaker will be there for this very session. So we are what I want to say is that this will be organized on 7th of December, and I just want everybody to take advantage of these very challenges, whatever challenges are there and issues are there in case of cross-border insolvency and group insolvency. This is what I want to say. Thank you so much.
Thank you, Sandeep ji. I now request Ms. Rasmi Chausharia to offer certificates of appreciation to our speaker, Mr. Vinay Kumar Singhania, and the moderator, Sri Mahesh Chandra Gupta. And I also request her to offer a formal vote of thanks. Over to Rasmi.
Vivekji, the certificates of appreciation to Vinay ji and
Rasmi, your voice is breaking.
okay. Certificate of appreciation, Vivekji, you will be sharing, na?
Definitely.
Ha, please share, na? Thank you, Vinay sir. And this is a certificate of appreciation from IPNet to you. And this is the virtual certificate, but we are sure that the original will reach you. And now we want to thank our moderator, Sri Mahesh Chandra Gupta. And the certificate of appreciation to Mahesh sir. Thank you, sir, for wonderfully moderating today's session. And okay, and now I from IPNet East I'm privileged to extend the vote of thanks for today. I would like to express my sincere gratitude to IPNet for providing me with this opportunity. Today's event was much more than a webinar. It felt like a start of something truly significant, a movement that will shape our professional community in the years ahead. First and foremost, I extend my heartfelt thanks to our esteemed keynote speaker, Mr. Narayana Kanna, who had tirelessly tried to answer each and every question of us. Thank you very much, sir. And Mr. Binay Kumar Singhania, who has been the keynote speaker for today's session. So your presence has added immense value to this occasion, and your insightful words and vision have inspired all of us to think bigger and strive for excellence. Thank you both for gracing us with your time and wisdom. I would also like to thank our president, Dr. Ashish Makhija. Sir, your relentless dedication and visionary leadership continue to make IPNet a platform of unparalleled importance. Your guidance gives us the confidence to reach new heights, and for that, we are truly, truly grateful. A special note of thanks goes to our dedicated coordinator, Sri Mahesh Chand Gupta. Your invaluable insights and perspectives have reached today's discussion, offering us new directions and understanding that will surely shape our future work. Thank you, sir. I would also like to extend my sincere appreciation to transition and the technical support teams. This is the team which works behind the scenes, ensuring that everything runs smoothly. Thank you for your unwavering support and flawless execution. Finally, to everyone who participated today, your presence, enthusiasm, and active engagement have made this event truly remarkable. Together, we are building a community that will not only foster professional growth, but also drive innovation and collaboration in the insolvency profession across India. Thank you once again to all those who contributed, participated, and supported this remarkable initiative. This is only the beginning, and I look forward to what we will achieve together in the future. Thank you, sir.